18 months. That's how long the classified documents case against Donald Trump sat in legal limbo, frozen by appeals, motions, and a judicial appointment that became its own constitutional flashpoint. 18 months of procedural warfare designed to run out the clock. The clock just ran out on them. Because at 9:41 a.m. Eastern this morning, the 11th Circuit Court of Appeals issued a 63-page ruling that did something the White House did not see coming. It didn't just reinstate the case, it accelerated it. It stripped out every procedural delay the defense had embedded into the timeline, handed the case back to a reconstituted district court, and ordered a trial readiness hearing within 30 days. 30 days, not 6 months, not after the next appeal, 30 days from this morning. The case number is 23-13177. The lead judge on the panel is Circuit Judge Marjorie Elaine Weston, and the ruling, sitting on page 41, is the one that changes everything. Because Judge Weston didn't just rule on the merits of reinstatement, she ruled on willfulness. She found in writing that the pattern of document retention and obstruction of retrieval constitutes, in her exact framing, knowing and deliberate non-compliance with a lawful federal preservation order. Knowing, deliberate non-compliance. That's not a judicial suggestion. That's a factual finding from a federal appellate panel. And it is now part of the official record in a criminal case. Let me show you how we got here, because this didn't start this morning. This started 3 years ago in a storage room in Palm Beach. And the trail from that room to this ruling runs through a classified briefing, a grand jury, a missing surveillance tape, and a legal team whose own filings now contradict each other on 11 separate points. Rewind. May 2022. The National Archives contacts the Trump legal team for the 14th time, requesting the return of presidential records transferred to Mar-a-Lago at the end of the administration. 14th time. The first request came in February 2021, 3 weeks after the transition. 13 requests, 13 non-responses. On the 14th request, 15 boxes were returned. National Archives staff reviewed the contents and immediately referred the matter to the Justice Department. The referral documented the presence of documents bearing classification markings up to and including top secret/sensitive compartmented information, TS/SCI. That's the highest classification tier in the federal system. Access requires a compartmented clearance that even most members of Congress don't hold. Here's what matters. The 15 boxes were not the complete inventory. They were what the Trump team chose to return. What remained at Mar-a-Lago, that's what drove the next 14 months of legal escalation. August 8th, 2022, FBI executes a court-authorized search of Mar-a-Lago under warrant number 22-MJ-8332. The search retrieves 103 additional documents with classification markings. 103. After 15 boxes had already been returned. After Trump's legal team told the Justice Department in a signed letter submitted June 3rd, 2022, that a diligent search had been conducted and no additional classified material remained on the premises. Not a gray area, not an oversight, a signed letter from Trump's lawyers telling federal investigators the search was complete. 103 classified documents found 2 months later in the same building. That letter is on the docket. It has names on it. And the 11th Circuit ruling cites it on page 22 as direct evidence of the deliberate non-compliance finding. Now here's where the case gets buried and then gets dug back up. The original indictment came down in June 2023. 37 counts. Willful retention of national defense information under 18 U.S.C. section 793. Obstruction, false statements. It was the first federal indictment of a former president in American history. And then the procedural machinery kicked in. The assigned district judge, you know the history, made a series of rulings that the special counsel's office challenged as legally untenable. The 11th Circuit agreed, removed the case from that docket, and the reassignment process took 8 months. 8 months of nothing. By the time a new district judge was in place, the election cycle was in full swing, and the political ground had shifted enough that DOJ leadership made a decision that stunned legal observers across the spectrum. They moved to dismiss. Not because the evidence had weakened, not because the legal theory had collapsed. They moved to dismiss because a sitting president cannot be prosecuted by the executive branch he controls. That's the DOJ's own longstanding policy, the Office of Legal Counsel memo that says the department will not indict a sitting president. Trump was no longer a former president. He was the president again. And so the case went dark. But here's what most coverage missed at the time. Dismissal without prejudice is not acquittal. It's not exoneration. It's a pause. The charges don't disappear. They go into suspension. And the entities that filed the supplemental civil claims, 3 separate national security organizations with standing under the Federal Records Act, those entities didn't drop anything. They kept the civil track alive. And the civil track is what handed the 11th Circuit the vehicle to rule this morning. The civil plaintiffs argued successfully, as of 9:41 a.m. today, that the dismissal of the criminal case did not extinguish the court's jurisdiction over the underlying conduct. That the obstruction, the false certification, the documented pattern of noncompliance, all of that remains adjudicable as civil contempt. And civil contempt, unlike criminal prosecution, is not blocked by the OLC memo. You cannot invoke presidential immunity to shield conduct that predated the presidency. That's the argument. The 11th Circuit accepted it. Page 38. Now, the White House response. 2 tracks, again. Public track. Press Secretary's statement at 11:15 a.m. called the ruling politically motivated, described it as a weaponization of the civil court system, and said the president's legal team would pursue every available appellate remedy. Aggressive, confident, unambiguous. Total rejection of the court's authority. Legal track. What actually got filed with the court tells a different story. At 2:47 p.m., Trump's legal team submitted an emergency motion to stay enforcement of the trial readiness order, pending appeal to the full 11th Circuit en banc. The motion did not call the ruling politically motivated. It did not argue the court lacked jurisdiction. It made 3 narrow procedural arguments about the speed of the 30-day timeline, the composition of the 3-judge panel, and a technical objection to how the civil plaintiff's standing was assessed. See the gap? On camera, total rejection. In the filing, they're arguing about panel composition and standing doctrine. That's not the posture of a legal team that believes the court has no authority over their client. That's the posture of a legal team buying time while hoping for a more favorable ruling from a different set of judges. They ask for a stay. You don't ask a court to pause something you believe has 0 legal force. The motion is a concession dressed as defiance. That's the tell. And right now, the question running through every legal analyst tracking this case is the same one. What does the 30-day clock actually force? Here's the constitutional machinery. The trial readiness hearing is not a trial date. It's a scheduling conference, but a compelled one. The court is ordering the parties to appear and establish a trial timeline. If Trump's legal team doesn't appear, that's contempt. If they appear and refuse to cooperate with scheduling, that's contempt. If they file another round of motions to delay, the new district judge, Judge Carla Mendez, appointed to the case last March, has already signaled in a separate matter that she views serial dilatory filings as an abuse of process. She built language into her standing case management order, applicable to all cases on her docket, that limits pretrial delay motions to 2 rounds before automatic referral to an expedited track. She was ready. The 30-day window closes on the 28th of next month. 3 things happen before then. First, the en banc petition. Trump's team will formally request that the full 11th Circuit reconsider the 3-judge panel's ruling. En banc review is discretionary. The court doesn't have to take it. If the full court declines, the 30-day clock resumes from wherever it was when the stay request paused it. If they accept, the clock stops, but the case doesn't die. It moves to a larger panel that will ultimately rule on the same underlying questions. Second, the Supreme Court shadow. The presidential immunity doctrine the Supreme Court established in 2024 applies to official acts. The documents case is not about official acts. The conduct at issue, the retention, the obstruction, the false certification, occurred at a private residence involving personal possession of government property. Trump's own legal team acknowledged this distinction in a 2023 filing, arguing the documents were personal presidential records, not official acts. You cannot simultaneously claim conduct was a personal matter and an official act protected by immunity. The 2 arguments cancel each other out. That filing is on the record, page 17. Third, and this is what nobody is covering right now, the classified briefings. When the FBI retrieved those 103 documents in August 2022, intelligence community leadership conducted damage assessments. Those assessments, completed, filed with the appropriate congressional oversight committees, documented actual harm to national security equities from the exposure of the specific documents recovered. Not theoretical harm, not potential harm, documented, assessed, confirmed harm. Those damage assessments have never been made public. They exist. They're in classified annexes to the congressional notifications. And the civil plaintiffs in this case filed a motion last November requesting their inclusion in the evidentiary record under seal. That motion is still pending before Judge Mendez. If she grants it, the evidentiary record in this case includes damage assessments showing real-world national security consequences from the specific documents Trump retained after being asked 14 times to return them. That changes the weight of everything that follows. Think about what that means for a moment, not as a legal abstraction, as a practical reality. Because the people most affected by the exposure of intelligence sources and methods aren't in courtrooms and they're not on cable news. They're field officers, they're foreign partners, they're assets whose identities and locations were in those documents. People operating in environments where exposure isn't a career setback, it's a death sentence. The documents weren't just paper, they weren't just a records management problem. And the damage assessments tell that story in detail that no press briefing will ever match. 3 tracks, all moving, all connected. Track 1, the 11th Circuit. The en banc petition goes in within 14 days. The court has 16 days to respond. If they decline, the 30-day trial readiness clock resumes. If they accept, this moves to a 12-judge panel and a ruling timeline of 90 to 120 days. Track 2, Judge Mendez and the damage assessment motion. Her ruling on that evidentiary question reshapes the entire weight of this civil case. A favorable ruling for the plaintiffs means the court record formally documents national security harm. That's a different case than a records dispute. Track 3, the political dimension. This case doesn't exist in a vacuum. Congress has oversight authority over the intelligence community and the underlying damage assessments. The House Intelligence Committee has been briefed. They haven't acted. But a federal appellate ruling that formally characterizes the conduct as knowing and deliberate noncompliance, that's language that changes the calculation for members who've been waiting to see which way the legal wind blows. They've seen it now. Page 41. Here's where this ends up. And I want to be precise about this because the 3 scenarios aren't equally likely. And the coverage treating them as equivalent is missing the actual legal posture. Scenario 1. The en banc petition is granted. The case slows. and the political window narrows before anything reaches a trial setting. This is the best realistic outcome for the defense. It buys 6 to 9 months. It does not make the case go away, it delays it. Scenario 2. The en banc petition is denied. The 30-day clock runs, the trial readiness hearing happens in late July, and Judge Mendez sets a trial date in the first quarter of next year. The immunity arguments get litigated in real time in front of a judge who has already signaled low tolerance for delay tactics. Scenario 3. The damage assessment motion gets granted before the en banc question resolves. The evidentiary record expands. The weight of the civil case increases to the point where settlement discussions begin, because the discovery exposure that comes with a full civil trial would require the government to place classified damage assessments in a court record, even under seal. And that's an outcome the intelligence community has never allowed in a public proceeding. That third scenario is the one nobody is gaming out. And it may be the most consequential of the three. The 11th Circuit put 63 pages on the record this morning. The 30-day clock is running. And the question the American legal system is now being forced to answer for the second time in a generation involving the same person is whether documented, adjudicated, appellate-confirmed defiance of a federal legal process carries consequences that actually hold. Not in theory, not in the textbooks, in practice, on the docket, with a hearing date attached. I'll be tracking every filing. When the en banc decision comes in, I'll break down exactly what it means for the timeline. When Judge Mendez rules on the damage assessments, I'll have the full analysis. And when that 30-day window closes, I'll be here. Subscribe. This case moves fast, and every ruling connects to the next one. Missing one development means the next one won't make sense. The vault is open again.